say the tank stakeholder group to consider groundwater quality objectives for inclusion in regional plans. So it's not the be-all and end-all, it's the beginning of a conversation around what no degradation of existing groundwater quality for the Heretaunga aquifer might look like. And so it will be something that's on the tank stakeholder group table for future discussions, no doubt. And perhaps on the table for other stakeholder groups around the country to think about as well. So this report is really just, a stock take. It's a decision that's come out, done and dusted. Now we have to put it into action and work with it. There's no further timeframes for appeal rights or anything like that.
Councillor Bevan. Thank you, Chair. I'll confine myself at this point to a comment and a question. I was somewhat surprised, number 8 in the paper here, where you outline what the HBRC case consisted of, that you didn't actually elaborate a little bit more on the unders and overs argument there. And correct me if I'm wrong, Gavin, but if I understand the unders and overs argument that we've tried to make correctly, it basically goes along these lines. You can degrade the quality of water in one part of our area, provided you are improving the quality of the water in another part of our area, and then you can play one off against the other and argue that you're actually overall improving the quality of the water in your total area, even though one part of it's getting degraded. That's fundamentally what this argument's about?
Having read Cabinet papers, that was Cabinet's intention. Yes, that across a whole region you could do that, but equally the unders and overs approach could be at a smaller scale than that. So in a subcatchment you can have an under, and in another subcatchment within the greater overall catchment you can have an over.
Right. So,
or in our case we were saying that there are going to be inevitably some hotspots within the Heretaunga aquifer, but the Heretaunga aquifer as a whole is still in pretty good nick. In terms of our case, we were probably more geared towards arguing that the no degradation statement was way too absolute, and in hindsight my opinion is that perhaps we just didn't see this whole argument about the unders and overs thing being a biggie, because it was a given that that was what that's what the government had intended. Lo and behold, the court came to a different conclusion on that.
yeah, but I'm not sure that the hotspots thing is relevant to this discussion, because I would have thought a hotspot was an existing condition which the court said is part of the current state. But anyway, look, let's not go down that track. The concern I've got about this from an iwi perspective is, if you can degrade the water in one part of your area or your catchment and you can improve it in the other and say we're meeting our obligations here, what it means is that, for instance, Mana Ahuriri's water might get degraded on this basis, and as long as you're improving Tamatia's, that's fine. But Mana Ahuriri won't be very happy about that, and I would have thought any of the people sitting around this table faced with that situation would be pretty angry about the relative degradation of the water in their particular part of our total catchment area. So I've got some real problems with our interpretation of this and the position we took. And I can remember sitting here, and I don't know whether it was a regional planning committee meeting or whether it was an environmental and services meeting when this was run past us, and I can remember several of us saying, that doesn't make any sense to us. It's not common sense to make that argument, and I still believe that that's the case. So that's my comment. My question really relates to what we were talking about before, which is the terms of reference and our requirement to come to this committee when we're faced with court cases, and I want to know what steps we actually took to meet our obligations under the terms of reference by bringing the positions that we were going to take to the court to discuss with this committee and get the sign-off, because I can't remember that happening.
Do you remember? It did. Yeah, well, yeah.
So obviously change 5 and the appeals were lodged a good few years ago. well before the revised terms of reference that are in your agenda today. So the terms of reference for this committee didn't incorporate anything around the providing of the, if I recall, providing the direction around what the scope of appeals may or may not be. But even given that the black and whiteness of the then terms of reference, my recollection is that when we did have the 4 appeals in the door lodged, we reported the nature of those 4 appeals to this committee. Perhaps even provided copies of the appeal in full. And I recall that as a result of that, there was a general agreement that I'll go back a step. The court really has a strong preference for those attending mediation to have the authority to make agreements and sign up to agreements there and then on the day. They are not in favour of people attending mediation and saying, "Yep, good idea, but I have to go home and check with my masters." They frown on that kind of practice. So with that in mind, the staff who were going to be in attendance at the mediation sessions, primarily myself and Helen Codlin, Helen was given delegated authority to negotiate and settle anything arising at Environment Court assisted mediation. But to get the to get the guidance on what Helen can or couldn't agree on, we staff liaised with the co-chairs of this committee. So it was Fenton and Toro. So that was the extent of the interaction, as I recall it.
All right, so the lesson for us is we need to be very careful about the nature of the delegations that we give in future.
In that case, because the council's decision or the commissioner's decision was as we had recommended, that was our starting point. So we didn't change. Our scope or substance for resolution was very little. That was we wanted to, we were holding the line. So it wasn't that we amended a we're amending our decision. Yeah.
It seems to me that we're going down a track of regurgitating or revisiting the whole scenario. Now, the suggestion is that we get those objectors and bring them in this room and we have a discussion with them. The Environment Court has made a decision. Talking to that objector, to the person who put the submission up, and have agreed with those people. Now, are we an Environment Court? No, we want them sitting here around this room to have a discussion. It seems absolutely ridiculous that we got to regurgitate all of this stuff when it was made by an authority who we accept have an expertise in that area. One or two may say it's now unworkable, it's in the too hard basket, or whatever. But the decision has been made that those 2 paragraphs remain. Now, I'm not going to go there and attack 4 environmental court judges that say, hey, you were wrong. Why are we having this conversation? I think that the decision has been made. The objectors put their case forward. It says clear stately, well, maybe not in this one, but in the other one, that council didn't argue with their evidence, and the court made the decision. Mr. Chairman,
I think this report.
I think the report has merit.
Well, it's
and
just
now
an
we've got to make
explanation,
it work.
and we move on. That's right.
And we've got to
it's
make
an
it work.
explanation, yeah. And we'll get to recommendations before 6 o'clock, hopefully. Councillor Belford.
With respect, I wish it were that easy. What I've read in this report and what I've heard in the presentation is nothing like that the staff thinks the Environment Court has made an intelligent, correct decision. The entire thrust of this is that they screwed it up and that we have our fingers crossed waiting for a different decision later on down the path. That's what our staff position is. Can somebody explain?
Point of order here.
So I'm not confused about our position. Do we 100% support the Environment Court decision? Do we?
There are two parts. We have no issues with the decision that they made in terms of reinstating the objectives. We got to work with that, and we will through the tank process. It's the same thing as saying, you know, it's got no degradation of groundwater quality. It's just like mana aki. Those are position statements. What does that mean? And working through that process. All we were flagging here is that there are some implications in the future for their reasoning, the reasoning in terms of how they came to that. And it's out there now. Environment Court decisions, you know, don't mind any other Environment Court decisions. All we were doing is flagging. There are some issues there. They will be tested. They will be discussed at other positions. But we're not waiting for anything to say from another process to inform or determine how we might deal with tank. Tank is what it is now. Those objectives are there, and we have to have those discussions now, using mana aki as a good basis as well.
Yeah, Mr. Chairman, like it or not, we learn as we go on all these things. Staff did what they did. The Environmental Court has come back with some observations and some recommendations, and I think they're actually good ones. And I think this thing about being aspirational is good. I don't think we should be saying we can't do this and we can't do that. If you say you can't do it, then it's not going to happen. And I believe that we as people who are meant to be leading things, we have to be aspirational, and we have to try and go for the highest level of quality that we can get. Even if we don't achieve it, at least we've said it and we've had a go at it.
Well, we seem to be. Is someone happy to move the report and we could get on with it? I don't think there's any more questions, is there? Corona's got a question.
I'd just like to say we'd like to accept the Environmental Court decision and find a solution to fix the problem.
That changes the resolution.
No, he's just making a comment.
I have a question, Mr.
Question,
Chairman.
here we go.
It's on page 32, 13 and 14. Only 13. Is 13 part of the court's decision or ruling? The control of the use of the land. Did the court say that? Doesn't say it, but I do see in 14, fail to even aspire to controlling the land. It's not talking of the water or anything else. If what I'm reading here is the court is worried about the use of the land, simple control, get the stock off there or something. So I would like to know if the whoever put this application in could tell us what it was they were asking for. Because we're not talking about the water or the river. So it would have been nice to have them here today to ask those questions. So that's the question I'm asking. 13, is that did the court say that, or was that just been rewritten?
Paragraph 13 is something that's lifted from the court's decision. It's got a footnote there, footnote 16. So the court made some sort of remark like that in paragraph 29. They say that the function of the regional council to control the use of land for water quality purposes is not optional, but they don't say what that control looks like. Does it look like earthworks? Does it look like vegetation only? Does it look like stock exclusion? They didn't go anywhere near that kind of level of detail.
That's why, Mr. Chairman, it would have been nice to have those people here to answer those questions, because they may have a solution, very simple. But if we're going to slag off other things, well then we'll never know. And once again, there's a cost to somebody here, and there's probably some cost will go against the iwi, against us. And as Marriedom, we will miss out on something else. Our monies have been redirected. So we've got to look at the bigger picture. So.
Kia ora. Let's get to the resolution, I think. Someone happy to move that we receive this report? Karona, thank you. Seconder for that. Thank you. You wish to speak, Karona? You good? Seconder. Other speakers? Councillor Graham. Oh,
I wish to speak.
hang on. Oh no, you didn't second, did you? No, you're right. I'll come back to you, Councillor Graham.
I have some major concerns about this report because we're actually receiving a report from our staff. We're not receiving the environmental report, which when I sped read it, I misunderstood that. I have concerns that our staff haven't really accepted the environmental decision, and it shows in this report. But I have even greater concerns than that. I have concerns that it says here, fails to even inspire. And I'm part of a council that fails to even aspire. And I have another concern too. The iwi spent $100,000 on this. So Marriedom was the one that went out on a limb and did this job for us, did this job for our community, not us sitting around this table. And so I have some real concerns about accepting this paper as it is. Of course, accept the environmental decision, and I think we've got to go forward and we've got to work with it and make it work. And it's not going to be an easy trail, it's going to be hard. But we've just got to bite the bullet and make it work. And all I can say is, thank goodness we've got an iwi that has the courage to do what they did.
Thank you, Chair. I'm also going to vote against this report because that's the only way that I can find to express my disappointment with it. This report, in my mind, is no more than a thinly disguised attack on the court's decision, which I think is a wrong thing to do. I'm disappointed that Ngāti Kahungunu, who were the appellants in this matter, weren't invited to come and speak to us about this report and give us their views. I'm really concerned at the some of the comments that are made about the unders and overs decision and so forth. So, and I actually don't think we should have even ended up in court over this. I'm also concerned about the fact that in my view, we haven't really properly met the terms of reference in terms of engaging with this committee before we decided on our approach to the court case itself. So, for those reasons, I'm going to oppose receiving this report.
Thank you, Mr. Chairman. This is a factual report. It isn't actually expressing whether any particular staff member believes or doesn't believe in a particular course of action. It actually states the facts as they are. It relates to the issue of not being consistent with the direction of the National Policy Statement for Fresh Water that will raise issues around the country. And that was what the staff have drawn our attention to. There are likely to be challenges in the future as to what is meeting that, and it does raise questions around that. This is an object that has always been in this particular region resource management plan. When we did the plan change for pragmatic reasons, it was looked at what could be met. And I guess I have to ask myself, the judgment actually quite clearly stated what can the consequences of not achieving this objective be, and in capital letters replied to their own judgment. This is what the judgment said, nothing. And it said that in capital letters. So here's an objective of which not meeting it actually has no consequences, which may or may not be helpful to anybody. However, for the Hiratonga, what does no degradation, where does that greatest threat lie? And it seems to me there are probably two areas that we most need to consider in the future. One is probably urban stormwater management over the unconfined aquifer, and what inevitably is an urban...
Mr. Chairman, are we going into the debate of what bad things about Hiratonga? I mean, where's this going?
Talking fact.
one of the areas of degradation that could be have the greatest implication for this in the Heritonga area is urban stormwater. The second will be wastewater management, such as septic tanks over the unconfined aquifer, especially overloaded septic tanks. So those probably will be areas in the future that we will need to address in order to be aspirational in meeting this objective. Those would be the first two areas, I would think, on the Heritonga that would attract the attention in order to look to meeting that objective. Factual, Mr. Chairman.
Put your microphone on, please, Uncle. Thank you.
There's a heck of a lot of debate, and granted, there's some specific points. I'm still looking at a clinical way that an environmental court, which is a higher authority than Walter Wilson or Jack Smith or Uncle so-and-so, we will always have an opinion. But this was a judgment. All the opinions will come, and from me as well. We need to make it work. I think the motion is not strong enough. I think the motion should be give effect to the decision of the Environment Court, and start pussyfooting around and saying, well, we'll receive it, put it in the dust shelf, or are we going to be at this time on Christmas Eve 2016 arguing about get that iwi here we want to have and regurgitate it and all the rest of it, and then bring up instances, or what about the water quality there, what about the quality? This is the decision. If we're going to be continually guided by our emotions, I suppose, this is an unemotive decision. Now we're adding emotion to it. Come on, come on. I say it should be given effect. But mind you, I'm not going to get that sort of thing, but
If that's an
at the moment,
acceptable amendment, I'll second it.
I'll move amendment.
No, you've already spoken. Good try. Lovely try. Other speakers, I'll go back to the mover to sum up. You wish to sum up? You good? I'll put the motion in. All those in favour, please say aye.
Aye.
Contrary, no. Let's have a show of hands. All in favour? Yeah, and so another report that's not
I think
received.
it's premature. myself.
Yeah, the nose. I've asked for the nose. Asked for Rex to show his nose. Yeah.
Is this the nose?
Can I vote twice? No.
Another
There
thing
was three in favour.
unresolved.
Oh, no, just not received.
No, just not received.